Welcome, everyone. Welcome. Thank you for being here. My job is to just do a quick introduction and then get out of the way as quickly as possible. My name is Stephen Collis. I am a law professor here and the faculty director of the Bech-Loughlin First Amendment Center. The First Amendment Center is so pleased to be able to host this event along with the School of Journalism and other co-sponsors. Our aim is to advance knowledge of the First Amendment, and we're thrilled today to be able to have an event that can do that. Just very quickly, for those of you who are interested, there is going to be a question and answer in the Sheffield Massey room with David McCraw from the New York Times. Wave, David. Immediately after this. So if those of you would like to go to a little bit more quaint setting, or you can kind of have a little bit more of a quieter Q&A, please just proceed over to the Sheffield Massey room immediately after this ends. I also want to thank my research assistant, Sydney Jean Godfrey, who organized this whole thing. Sydney Jean is a Georgetown graduate, who's also the editor-in-chief of our law review and has put in tremendous work to making this happen. So Sydney Jean, take a bow, please. Thank you. And finally, I'm going to introduce one of our distinguished panelists who will then take it from there. She is going to act both as a panelist and a moderator today, and she will introduce the rest of the panel. So I will introduce Amy Sanders. Professor Amy Sanders is an award-winning journalist, attorney, and tenured associate professor in the School of Journalism and Media at Moody College of Communications. She serves as the editor of the journal Communication Law and Policy and studies the legal regulation and ethical use of emerging technologies with an emphasis on freedom of expression and democratic values. We are lucky enough to have members of Professor Sanders' Plan 2 honors class, Protection for Speech, Press, and Protest with us here today. Professor Sanders.
Thank you so much. First of all, welcome to our panel, Actual Malice, Ongoing Threats to New York Times versus Sullivan and its Progeny. I have to say a big thank you, of course, to Professor Collis and the Bech-Loughlin First Amendment Center for having us here at Texas Law. I'd also be remiss not to thank Dean Rachel Mercy from my home college, the Moody College of Communication, and the School of Journalism for also helping to support this great event. As Professor Collis said, I will be your lion tamer for today's discussion, and it gives me great joy to introduce our panelists to you. To my immediate left, we have David McCraw, who serves as the lead newsroom lawyer for the New York Times. He's been at the Times for more than 2 decades and currently holds the position of Senior Vice President and Deputy General Counsel. He's the author of the book Truth in Our Times, Inside the Fight for Press Freedom in the Age of Alternative Facts. If you have not had a chance to read his book, I highly recommend it to you. It tells a great story about the Times coverage of Donald Trump, Harvey Weinstein, the rise of political polarization in the country. It is quite a read. To his immediate left, we have Lyrissa Lidsky, who is the Raymond and Miriam Ehrlich Chair in U.S. Constitutional Law at Florida Law. I have to pause a moment and say, go Gators, as it's my alma mater. She previously served as the Dean of the University of Missouri School of Law, and the focus of her research and teaching is at the intersection of tort law and the First Amendment. Her emphasis is on defamation and free speech issues on social media. Relevant to this crowd, of course, Professor Lidsky is also one of us, having received her law degree with high honors here at Texas Law. She also happens to be my scholarly hero, a term that I stole from her when she was talking about working on the restatement of defamation and privacy with the legendary and great Robert Post. To Professor Lidsky's left, we have Justin Nelson, who is a partner in the Houston office at Susman Godfrey. Most recently, Justin represented Dominion Voting Systems in its landmark defamation case against Fox News, which you may know resulted in a $787.5, we don't want to forget that half, $1 million settlement, which many of us believe is the largest settlement in a defamation case to date. He's a former law clerk to Justice Sandra Day O'Connor and for Judge J. Harvey Wilkinson. Justin has represented various parties as amici in the Supreme Court of the United States in cases ranging from intellectual property to antitrust to election law. So please join me in welcoming these great folks here to Texas. As any law student who's paying attention knows, context matters. In New York Times versus Sullivan, I think the context really matters. And depending on where you first learned about the case, you may have overlooked some key aspects of the case. So I'm going to do a little bit of level setting before we really get into the weeds here, just to make sure everybody's on the same page. Right? Most of us know Sullivan is a landmark First Amendment case, but few of us really understand the role the case played as a part of the civil rights movement. So let's quickly all transport ourselves back to the 1960s, and I'll lay the groundwork for what I know is going to be a tremendous conversation. Imagine the year is 1960. We're in Montgomery, Alabama, where a group of folks have been attempting to desegregate lunch counters. They're targeted by vigilantes, and there is some violence that occurs. Afterward, a civil rights group known as the Committee to Defend Martin Luther King and the Struggle for Freedom in the South places an ad in the New York Times retelling this story and others, and documenting the role of Alabama officials in suborning the violence. These officials, including Commissioner Sullivan, sue the New York Times and 4 ministers who work with Dr. King. Now, in many ways, the Sullivan case itself was not particularly unique. Segregationist officials across the South had learned how to weaponize the law of libel as a means of punishing and silencing their critics. At the time, of course, the First Amendment provided no protection for journalists or critics. Falsity was presumed, and the only defense was absolute truth. If we return back to the Sullivan case specifically, an all-white jury awarded L.B. Sullivan $500,000, the equivalent of $5.2 million today, marking the highest libel verdict in the state at the time. But that's not the whole story. By 1964, the New York Times, CBS, the Associated Press, and other media companies faced more than $288 million in damages in libel cases being brought by segregationist officials in the South. By comparison, that's $3 billion in today's dollars, more than Smartmatic's current defamation lawsuit against Fox News. Now, the goal of these lawsuits was simple: to silence media companies and others whose speech was viewed as supporting the civil rights movement. Now, we know the New York Times ultimately prevailed in the Supreme Court, where the justices voted unanimously in favor of the newspaper. Justice Brennan, in articulating the First Amendment's requirement that public officials prove actual malice, said the court decided the case, quote, against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government officials. So I want to start with a question for all of you by asking you to comment on the legacy of Justice Brennan's opinion in Sullivan, right, combined with the series of pro-free speech decisions that follow, right? Curtis Publishing versus Butts, Gertz versus Welch, Philadelphia newspapers versus Hups. I mean, the list goes on and on. So David, let's start with you.
Thank you so much, and I have to start with 2 points here about Texas law. My boss, the General Counsel of the New York Times, Diane Braden, is an alumna of this institution, so she sends her regards. And second, I want to thank Professor David Anderson, whose thinking so affected mine over so many years, so thank you for all you've done for media law in this country. Times versus Sullivan did exactly what Justice Brennan intended it to do, and that is it was designed to drive away plaintiffs who were using libel suits as a weapon, not to protect their reputation, but to get unpleasant coverage, shut up. And second, that it was designed, I guess the flip side of that, to encourage newspapers to be brave, to newspapers to take chances, that when they know and they feel and they understand, when they think in their minds that they're telling the truth, that they will be protected. And that was an incredible gift that actually so worked. I mean, one of the things I try to, when I talk to other in-house counsel, that I really try to stress, and our outside counsel as well, which is we as lawyers should not take away what Justice Brennan gave us. When we induce fear in journalists, when we make them worry that a libel suit is hanging over them like that shadow of the condor in a bad movie that's about terrible things about descendants on them, we do a disservice to that tradition, that what we need to do is understand that the actual malice standard works. It punishes liars, but it protects those who try to tell the truth, and we need to embrace that. And so it did, in fact, serve as a barrier to libel suits where we do not see as often as once was the case those libel suits that are without merit but are brought to run up legal costs, get discovery of people in the newsroom, do a lot of things other than what libel is intended to do, which is to create a remedy when someone's reputation is actually harmed.
Lyrissa?
So I would make 2 points also. The first is that when you read New York Times versus Sullivan, as I hope all of you have or all of you will, there is not a lot of precedent cited for the outcome, and for partly good reason. But one of the things I hope you'll notice is the citation to history. And the seditious libel was in the John Adams passed the Seditious Libel Act to try to prevent Thomas Jefferson from becoming president. And the real goal was to silence printers who, you know, at the time the press was quite partisan, and if you silenced the printers, maybe you could block Jefferson from becoming, the Federalists could block Jefferson from becoming president. And the Supreme Court looks to that incident as precedent. And what they say is the American people spoke. And in the court of public opinion, they said, we don't tolerate the government using libel law to suppress criticism of the government. That in a democracy, that is unacceptable because the ultimate locus of power is the people, and the people must be free to criticize those who govern them and have free reign. And so I think that's an important aspect of New York Times versus Sullivan that much of it remains important, but that's one I would bring to your attention when you're reading it. The other thing I would bring to your attention is if you look at US defamation law as opposed to defamation in other countries, you learn something instructive. So for a long time, UK recently reformed its law, but for a long time there was a phenomenon, there still is a phenomenon, it just is not as prevalent in using UK law, called libel tourism. And so if you're a powerful person and something is published on a global level, you would choose, you know, there's a little bit of forum shopping, but you would choose to go to the UK because powerful people can use libel law to silence their critics more effectively in the UK than they can in the US. And so for a long time, the other thing is I've spoken to lawyers, you know, Australian lawyers, UK lawyers, and they say that they cover different kinds of people differently based on how thin-skinned they are and how rich they are, because the thin-skinned rich can easily bring libel actions against news organizations anytime they come in for harsh criticism. And New York Times versus Sullivan makes it harder for not only public officials, but the thin-skinned rich to use libel law against journalists and others anytime they come in for harsh criticism. And that's more important than ever today. The importance of Sullivan has not waned. That's just as important as it ever was.
Justin?
Well, first of all, thank you for having me, and in addition to being grateful here at University of Texas to be part of this. I have to say I'm even more honored to be on a panel here with two people with a University of Florida connection. My father-in-law, who just passed, was the biggest Florida fan in the world. We called him Gator. He was such a big Florida fan. But we are still looking forward to the University of Texas, University of Florida football matchups. And
Absolutely.
and that, we know who we're going to be rooting for. So I agree with a lot of what's been said, but not all. I certainly agree that New York Times is a huge, huge, huge weapon for the protection of the press. And it is vital for there to be this protection that gives any media outlet the ability to publish without fear or favor. But David, I thought it was interesting, let me stir the pot a little bit. I thought it was interesting on something about what you just said, and it might have just been a slip of the tongue. Or maybe not. You said their version of the truth, right? Is it their version of the truth, or is it the truth, right? And who determines what is the truth? Is there such a thing as objective reality right now, right? And if we think that there is such a thing as objective truth, I personally think there is, then there has to be some mechanism for holding media companies accountable to some degree. I think you would agree with that, by the way, okay? In other words, as long as the protections are in place, whether they come from Sullivan, whether they come from many of the anti-SLAPP statutes that have been passed throughout the country, and I'd love to get into a discussion of anti-SLAPP because I think there are two parts of it. One is the substantive protections and one are the procedural protections, and one might come to different conclusions about both of them. But if you have those protections, and if you think that we need to protect truth, then defamation is one of maybe even the only ways to be able to get that result within the civil justice system or throughout justice whatsoever.
I wouldn't be a good lion tamer if I didn't allow you to respond.
Yeah. So no, this will be the only time I'll say this. That wasn't a slip of the tongue. Everything else will be a slip of the tongue. The point here is you can be wrong. I mean, that's the point here about Times versus Sullivan, that sometimes journalists, people who speak in any public forum, are going to get it wrong. And the test is really going to be a subjective one. If they are intending to lie, if they're intending to say something untrue, they're going to lose under the actual malice standard. If they have intended to tell the truth, and again, they could be wrong, that is not actual malice. And that's really the distinction I'm making.
But let's take it in now because of how the decision has been broadened. Let's just take, and I can't talk about the Dominion versus Fox case particularly, so we're not going to talk about that case. Let's talk about Donald Trump.
You're breaking hearts here. So.
I understand.
I can talk about it.
Let's talk about Donald Trump, okay? Donald Trump says that he won the 2020 presidential election, okay? That is objectively false, okay? Is it a subjective standard? It is reckless disregard in the case law, right? Do you have to, is it like a criminal insanity defense? Can he say, I'm not liable under New York Times versus Sullivan because I legitimately believe that I won the 2020 presidential election? I personally don't think that that's the right answer. I don't think it should be the right answer. I think actually, now maybe the case law is developed in a way to catch that through reckless disregard of the truth, but it to me, and this is, I think courts have developed over time, yes, it's subjective, but certainly you can point to objective and circumstantial evidence about what that person's mindset is, right? Or do you think that there is this insanity defense effectively?
Well, Larissa's going to bail me out here. But I remember that at the time that the New York Times referred famously to Donald Trump as a liar during the 2016 campaign, and a woman wrote in and said, you know, why are you doing that? Can't you tell he's delusional? He actually believes this stuff. I don't know the answer to that, right? But I think to go back to your point is that if you gave me an example where he's actually hurt somebody's reputation, then we're into the very evidence you're talking about. Lyrissa, bail me out.
Well,
Yeah, you've written about this.
I have written about this. So Ronell Anderson-Jones, who's a scholar at the University of Utah, one of the finest scholars in the country on these issues, we have talked repeatedly and written about the delusional defamer problem. So one of the first blog libel cases involved the Courtney Love. You may know her. She was married to Kurt Cobain. She's a singer and artist in her own right. But she is the essence of the delusional defamer, and she just says things, and she actually believes what she says.
It breaks my Gen X heart, by the way, that some people might not know who Courtney Love is.
Trust me, I teach this age every day, you trust me. But anyway, so a jury actually found that she was not liable because they couldn't establish the requisite kind of fault because she believed her own version of reality. So it is a problem with the standard, and the standard needs to be perhaps tailored in some way to account for that. I mean, normally we trust the native intelligence of juries to see through some of this, and I think in most instances we won't believe that the person really believes what they're saying. The Alex Jones case may have tested this to a certain degree, although I think the jury came to believe that Alex Jones, who had lied about the Sandy Hook parents, he had said they were crisis actors. It's hard to believe. I don't know of a more cruel defamation case, a horrific and cruel defamation case. But he, for a time claimed he just bought into his own, his own sources. But then I don't think the jury even believed that. And I think that's mostly what we rely on to deal with this delusional defamer problem. But I agree, it's a problem for the actual malice rule.
If there's any consolation, Justin, in the second day of my law school class talking about defamation, the picture of you and your team coming out of the courthouse is the first picture I put up, and the second one's of Courtney Love. Now, I don't try to connect the two, but I'm going to. But yeah, I mean, Lyrissa, are you... The current state of the law protects the Courtney Love, and you're saying maybe it shouldn't.
I think it does. I think maybe it shouldn't because otherwise, the E.G. Carroll verdict that Trump had. I mean, as soon as there was the verdict in the first defamation case, he goes right back out with the same story. He's like the undeterrable defendant. If the jury verdict was supposed to authoritatively set the record straight as to what the facts were, then you can't say he doesn't have actual malice the second time, or it just doesn't work.
Well, this is why it might... Go ahead, David, please.
No, go ahead, please.
This is why it might be truly an academic point and a distinction without the difference, because I do think juries and judges can see through it, and the reality of it is that if there is circumstantial evidence that someone should have known, okay, even if there is a subjective standard in the case law, that you're going to go to a jury if there is circumstantial evidence that someone should have known that it was false, even if they say that they did not know, which of course it is, as some of the case law says, it is the rare case where there is direct evidence that someone knew it was false.
Right, and I think, and I take both of your points here, and as you say, here's what the law is, and you're asking the question, where should it be? But you take someone like Sidney Powell, and in some ways, Sidney Powell in Times versus Social World has the best defense, because I think she actually believes some of that stuff. She said,
I think Mike Lindell does too. The My Pillow guy who perpetuated the, January.
And I bet in front of a jury they lose. I bet they say that level of self-deceit, I'm just not buying into.
Yeah, well, just like Giuliani recently, again. I think juries are generally savvy, not always in every case, but I still have optimistic faith in juries, thanks to my professors here in the audience.
Well, just to put it out there for the audience, like Justin, I too cannot speak about the Dominion voting systems case, as I was an expert witness in the case. But we've started down the road of criticisms of actual malice, and I want to get us there, and I want to talk about that because, of course, we're no longer in 1964. We're in 2024, and we're seeing what I would call increasing criticism of the actual malice standard by everyone from, of course, the former president, who we just referred to sitting Supreme Court justices. And so I'm curious what's behind these criticisms. Why are they bubbling up now? And what does that mean for our democracy and the election that we're about to have? And I'm actually going to start with Justin on this one.
Well, I think that what you're seeing is what is really interesting. From 2016, the criticism of New York Times versus Sullivan for a long time, and I think still is coming from the conservative side of the spectrum. Historically, you've had Justice Thomas and now Justice Gorsuch, who have been the most outspoken that New York Times versus Sullivan should be overturned. And recently in Florida, speaking of Florida, there has been obviously movement to loosening the New York Times versus Sullivan standard. And I think perhaps there has been a wake-up call a little bit within the conservative press to say, whoa, hold on a second, be careful what you wish for, right? Because if there is going to be a lowering of the standard, right, one can imagine that the people who are going to have more problems are not going to be institutions like the New York Times, who have massive sets of fact checkers and a fantastic organization that can review and vet and make sure that what they're publishing is accurate. But ones really on either side of the spectrum, not necessarily conservative, that don't have that infrastructure in place and are more likely to try to garner views and clicks rather than necessarily the truth. So it will be interesting, I think, to see whether the pendulum is going to swing the other way a little bit and what we're seeing along those lines.
Lyrissa?
Well, and when you think about the pendulum swinging the other way, you need to think that a lot of these recent large dollar figure, either settlements or verdicts, involve conservative actors. There was the climate scientist who recently sued a couple of conservative bloggers for criticizing his hockey stick graph on climate science and complaining that, or saying that was academic fraud. They also had when you read about it in the newspaper, they say, well, they compared him to Sandusky at Penn State. I think that's a little bit of a stretch. I think there was a little opinion there. But the point is they accused him of academic fraud based on climate science, and he won his lawsuit after 12 years. I think it's a Pyrrhic victory, but we could talk about that too. But $83.3 million against Trump, over $1 billion against Alex Jones. Who am I forgetting?
The Georgia poll workers.
Georgia
right?
poll workers. Rudy
140 or something.
Giuliani's taken bankruptcy over that. And so I think if you were on the conservative side, maybe you might not want to open up libel law, as Trump famously called for while he was running for office the first time. Trump, by the way, just in case you wondered, Trump has been involved in, the last time I looked, it was well, and that was several years ago, well over 40 different libel lawsuits, both as plaintiff and defendant. You would think that would make a person cautious about opening up libel law. But that came before Justice Thomas started calling for overturning New York Times versus Sullivan. And when he began, it was like a voice crying out in the wilderness. And you just thought, oh, that's never going to happen.
We laughed about it.
We laughed about
Many
it.
of us who do media defense work or who talk with journalists and media defense attorneys, when he first started saying those things, it seemed crazy.
And it was, because it's the foundational foundational case in all of First Amendment law and media law, which David taught me. And it just seemed crazy. But then Gorsuch joins him, although for different reasons. And I think they might be open. I don't think they're going to overturn Sullivan. I hate to be in the prediction business. It's a fool's errand. But they might be open to revising who might be a public figure. They might be open to tweaking at the margins.
Yeah, let me just add a couple thoughts to this, which is that I always come back to this quote, which I brought with me, about Sullivan. It may be said that such a test puts a premium on ignorance encourages the irresponsible publisher not to inquire, and permits the issue to be determined by the defendant's testimony that he published the statements in good faith and unaware of its probable falsity. That's from 1967, Justice White in the St. Amant case. There's nothing really new about the criticism. And what was said there is really kind of the underside and the things that concern anybody who cares about the information ecosystem, that yes, you get a Courtney Love-like case where her empty-headedness is a defense. She didn't know it was untrue. But I think when I get asked this question about the current criticism, I would say a couple things. One is, this is really driven in large part by all of our concern about what happens on the internet. That there is so much speech out there that is so wrong and so toxic, and there is a concern. And that's understandable. The thing to keep in mind, though, is reforming libel is not going to really address a lot of the disinformation and misinformation. It only addresses cases where there is an individual or corporation whose reputation has been harmed. Most of the disinformation and misinformation we're concerned about, or the bullying we're concerned about, doesn't really make a factual statement about anybody. It doesn't hurt reputation. It hurts society. It does something else. And that's not going to change even if we alter the libel law. Lies about the vaccines, lies about COVID, lies about immigration, lies about the election. Rarely, and Justin proved me wrong on this, rarely is there going to be somebody who can bring a reputational harm case over that. It's generally sort of thrown out there in the ether. But which I think brings to a point, and you brought up Ronell earlier in this, is that, and work that you and others have done, the problem here is the Supreme Court has for 50 or 60 years treated the speech clause and the press clause as identical. The same protection for Courtney Love is the same protection for the New York Times. Courtney Love tweeting falsely about a lawyer, the New York Times trying to get it right, and I hope getting it right, writing about important topics. The Supreme Court has treated the press and individual speakers exactly the same for purposes of the law in virtually everything, and I think we need to think about whether that's the right way forward in a time when everybody is a publisher, thanks to Instagram, Facebook, and everything else.
David, would you, I'm going to stir the pot again. I'm going to ask a question. You have full control over media law. Would you do New York Times versus Sullivan the exact same way as it came out, or would you root the media law protections in other places, whether constitutional or statutory?
Do I have my current job and need to keep it? If the answer is, yeah, look, you know, when I'm retired, come back and ask me that question. The thing to keep in mind, though, and you raise a really good question, and it's a question I pose to my students when I teach media law, is, and I've used this as the exam question. It won't be on the exam, so if you know any of my students, don't tell them. But you know, what would you do about it? How would you reform it? And I think at heart, it makes sense certainly for public officials, certainly for criticism of government, where public officials try to say that's about them. We can certainly debate about the definition of public figure, which the Supreme Court has not come back to since Gertz, as far as I can tell. And as I said, I do think that there would be, in my mind, the idea of having a different set of safeguards for private speech, for what I'm going to say is private speech, for individual speakers, makes sense. And it doesn't have to be the same generous standard that it is for the press. Now, I know everybody's sitting out there going, well, how do you define the press? And we'll get to that at some point in our lifetimes. But the point I would make, Justin, and I'd love to hear your thoughts on this, is that, and then Professor Anderson and I were talking about this, Lyrissa were talking about this as well, is that in a lot of libel cases now, the defenses are coming from the common law. It's a much more powerful litigation solution for media defendants because you can argue that that statement isn't a fact, it's an opinion. That is a complete defense. You can argue that it wasn't actually about the plaintiff, it was about a class of people, or the person wasn't identifiable. Common law defense, that's a winner as well. Many times you can argue that you're depending on the fair and accurate report privilege, that is, you're working from judicial documents or similar sort of documents. That's a winner too. You never get to the Constitution, and there are a lot of advantages to doing that, but we'd love to hear what you two have to say.
Lyrissa?
So I recently took over a treatise on defamation law from Judge Robert Sack on the Second Circuit. It's a well-known treatise. And I had to do the update memo for the first time this year, which involves reading every appellate case and blurbing every appellate case on defamation in the country over the last 18 months. And I was surprised. I teach this subject, have taught it for years. I was surprised to see how many decisions were decided on common law privileges, and especially the judicial proceedings privilege. Because what happens now, and another side note on this, we who teach media law, we tend to teach defamation too. I also teach it in advanced torts, just like David. But we tend to think about media cases as being the only kinds of defamation cases, but increasingly with the internet and social media, there are a tremendously more private people suing private people cases. And what happens is people get in a dispute and they start reporting each other to investigative bodies of all kinds. And so there's a rash of cases that had flown under my radar, despite doing this, for many, many years now, about that kind of privilege being used. And people say things in litigation. Now litigation, it was rare previously to have a complaint. How long was your complaint? You can say this, can't you?
It was long.
It
I
was
can say that
long.
because I read it.
It was, see, I can say, he can't say this, I can say this. It was, I think yours was over 200 pages, the Smartmatic one similarly. And the reason is that those complaints are really press releases in addition to being legal documents getting litigation started. And so you want to get the truth out from the moment you file the complaint. And they have exhibits, they have photos of like social media screen. I encourage you to go look at it. It's amazing. It's an amazing document. And the cumulative effect, showing they knew it was false, they lied. They knew it was false, they said this outrageous thing. They knew it was false, they put Lindell on again. They knew it was false. So the cumulative effect is great, and I know why it's enormously long. But that's leading people to sue based on things that get put in complaints or that are part of the litigation of a case. And that's why these privileges are much more important than I ever realized before.
Justin, do you have a comment?
Well, sure. I mean, first of all, Lyrissa, it's Sack on Defamation is the leading defamation treatise. Okay, I mean that and Small on Defamation are the two, and it's just so
I hope I can keep up the standards.
Exactly right, but it is interesting to me though that what you are seeing in many jurisdictions, and I'll broaden it just a little bit, is that there is this common law, but then you have it has been codified. Right? Both the common law privileges and in many jurisdictions now, the New York Times versus Sullivan standard, right? So it doesn't matter what the Supreme Court does or doesn't do in New York right now. It doesn't matter what the Supreme Court does or doesn't do to a large extent because there's an anti-SLAPP statute that talks about it. Whatever the fair report privilege is or judicial immunities, or you name some of the privileges that are out there, the statutes now speak to it. And so I think that has been an ongoing trend. I can argue it both ways on whether it's a good or a bad trend, okay? But it's certainly there, and I think it picks up on some of these themes.
Can I add one thing to
Of
that,
course.
Amy? So we're discovering, so in working on the restatement of defamation, you have to have 50 state surveys on literally every aspect of defamation law. And you have a team of research assistants and learning how to work with them and get these. But once the Supreme Court constitutionalized defamation law, the common law courts no longer differentiate what is constitutional, or sometimes they do, but a lot of times they don't. And so most jurisdictions are building some level of fault into the common law. It's no longer just a constitutional law thing. And I don't know how, if Sullivan were to go, you ever unravel I've called it the Gordian knot. I don't know how you slice through the Gordian knot now.
Right, and I mean, I do think that and you can correct me if I'm wrong here, but virtually every rule of law jurisdiction, at least in the West, excuse mistake. At some, that nobody thinks that it would be a good idea to go back to strict liability. That if a newspaper makes a factual error that is unintentional, that should immediately lead to liability. And so then you start asking, well, what the standard's going to be, and you start to look at things like in Canada, was there responsible reporting? That's the debate. A mistake was made, somebody's reputation was harmed, but there will be defense for responsible reporting. That sounds great, except in practice. When you are going to have judges making that decision after the fact, and that at the time the journalist wants to publish, cannot predict with great certainty how that's going to turn out. You have in England the public interest privilege. Was it in the public interest? I don't really quite understand how that works, but I'm not sure that does the right work for deciding what should be published and what should not. So that is, I think, the intellectual problem that is presented, that if you walk away from Sullivan, if there ever was that was going to happen, and I think that would be a mistake, as I said, especially when you're talking about covering public officials in government. What comes next is really hard to calibrate the right standard.
So some folks have said, and even some Supreme Court justices, that actual malice essentially gives us this breathing space that you're talking about, right? And my question then is, post Fox Dominion, post E. Jean Carroll with $88 million, right? So we're seeing these very large verdicts. The verdict in the Giuliani case was $146 million that the poll workers were awarded. Don't these 8- and 9-figure verdicts have a chilling effect on freedom of speech? Like, shouldn't, in a democratic society, shouldn't we be worried about that? That if people don't know where the line is drawn, that they're going to err on the side of not speaking? I mean, not everybody has David McCraw and the New York Times legal team, right? The Victoria Advocate here in Texas doesn't have that backstop. So what do these verdicts mean for the practice of journalism, for freedom of speech in our country?
Somebody want? Justin, did you feel like you were destroying free speech? No. That's what she's asking.
Who needs a lion tamer when you make comments like that?
Well, I can take this on. So I encourage everybody here in the audience to read David Anderson's article, Is Libel Law Worth Reforming?, which fundamentally influenced what I'm about to say. So libel law has this doctrine of presumed damages, and presumed damages, basically, you can presume from the nature of the statement itself, and as a practical matter, it's just not anchored in anything. And people can recover even if they didn't really suffer any harm to their reputation. And David has fundamentally influenced me in thinking presumed damages are a bad thing. There's a new article out claiming they're not, but by a guy at Fordham named Benjamin Zaparsky. But nonetheless, the problem is you start with damages that can be any amount almost, and then you get you get punitive damages on top of that. And now that you have these astronomical either verdicts or settlements, it encourages plaintiffs' lawyers to think they should bring one of these, right? Because plaintiffs' lawyers work, they can be persuaded to take a case based on liability is certain, or liability may not be certain, but if you win, the damages are enormous. And so this is luring people in the promise of a $787 million judgment.
Don't forget the half.
You're willing to take the risk. Yep, half. Yeah, because $500,000 is nothing to sneeze at, but I'd take it. So it is, and it sets the anchor effect higher in the public mind as to what is a reasonable amount of compensatories to award and then punitives to add on to that. And so I really do think it is that we've lost all, it's called the anchor effect. You've probably heard about the anchor effect. So when you start a negotiation, you want to hit a high number because that becomes the anchor against which you're negotiating. It's like an anchor effect for future damages, and it's bound to have a chilling effect.
You know those pesky plaintiffs' lawyers, right? I come at it a little bit differently. Let me speak more generally about this. I think that you have to have standards. And if you violate those standards, whatever those standards are, there have to be consequences to that. And if the alternative is there are no consequences, or people can just think they can do anything, or it's a cost of doing business, you are going to see the level of discourse in this country plummet, okay? And to blame, the fact of, plaintiffs' lawyers or whatever else for some decision to issue, in this case, something that is knowingly false or recklessly disregarding the truth, I just find fundamentally false. I also think that, I think you do have to separate there's the media cases and the private cases. Trump versus Carroll is a private defamation case, okay? And the reality of it is there are large awards across civil litigation right now, okay? And the other reality of it is a jury found that E. Jean Carroll was defamed by Donald Trump over and over and repeatedly. Recall that the first verdict was in the mid-single digit millions. I think it was 5 million, right? Mm-hmm. It was only the second time that you got the punitive damages and the awards that went up from there. And so, it's sort of what we teach our kids. Actions have consequences to some of this. And I know we're talking private plaintiffs, but it's also true on the media law front, okay? And do we want people and organizations to, yes, have breathing space, but also, yes, to take care that they are trying to get to the truth? I think the answer to that is yes. And again, forgetting about how we end up there, whether it's New York Times versus Sullivan or statutory, I think this has been really enlightening, and Lyrissa and David both, in terms of the background in international law is that we are basically going to end up in some similar type space. It might be that there are more costs before you get to a point of someone deciding. That might be a good or a bad thing. But to say that there is a free pass, I think, would fundamentally misread the First Amendment in history and really, really degrade democracy.
And a couple of things I'd like to say in response to the first thing you all should know is that when Justin and his colleagues brought that case, I did not hear anybody in media law say, oh, that's a really bad thing to do. So, we understand there are libel cases that should be brought. The other thing you should understand is that Justin's firm represents the New York Times in the largest case it has as plaintiff, so we do not have any problems with plaintiff lawyers.
At least not these ones, right?
Good to have a plaintiff's lawyer when you want to be a plaintiff.
But so we're not talking about like the abolition of libel. We're talking about the standard, and that the truth is that the New York Times rarely actually gets sued for libel, despite how much content we have, and that has grown exponentially. We generally have 3 or so libel cases a year. We publish, depending on how you count, between 150 and 250 pieces of content a day, okay? So the libel concern we have is, in my mind, manageable. And obviously we're defending all those cases, and we believe that they're in the wrong for bringing them. That doesn't mean that there should never be a libel case brought against anyone. But I don't think the size of the damages ever enters into our thinking, right? You know, in pre-publication review, we do not look at a story and go, well, if the damages are $1 million, let's go for this. But if they're 10 million, we're not going to run the story. We want to get it right, and the reporters want to get it right. The reporters, if they do not focus on what the damages are, they focus on their reputation. I've been sued for libel. I don't want to be sued for libel. I want to get it right. It goes to a little bit what Justin was saying about that people caring about the truth is fundamental to journalism. And it's one of the things that I think is always a little odd about the power of Times versus Sullivan. It has zero impact on how I talk to reporters before publication. A reporter comes in and shows me a story, it's incredible. I don't say, do you believe it's true? And he says, I sure do. And I go, good, let's publish this sucker. Okay? That is not the conversation. The conversation is, who are your sources on this? How did you get this? Have you thought about this? As a counter-narrative. I wrote a piece for the New York Times called How to Think Like a Libel Lawyer. And that piece talks about, I want to think about the counter-narrative. I want to think about it from the side of the person who's in the target of that story. That means, yes, when we write about Elon Musk, I want to think about this as Elon Musk would. And if they can convince me that this story's right, let's go.
Lyrissa, I'm going to let you have the last word on this.
So, talk about stirring the pot is Justice Gorsuch, when he said New York Times, on the shadow docket, the New York Times should be reconsidered. He said the press is no longer committed to getting it right.
Yes.
And public trust in the press is at an all-time low, which maybe explains some of cases being brought, big damages, et cetera. And so, and I do think that there's a quality problem, not for the reasons that people think, but because the staffs of newsrooms have been, you would say decimated, but decimated means killing off 10%, and it's been enormously more than 10% of the staff. And along with those people are people with expertise, long-term expertise. And so newsrooms don't look like they used to look. And so are they still committed to getting it right? I mean, even if you concede the New York Times is everybody else committed to getting it right?
Well, I do think that I separate the two issues, and I would separate the people we're talking about. I think at most newsrooms there remains a commitment to get it right. As you say, there's a resource problem. So there's a commitment here and a resource problem, and those two things need to line up, and they don't because of the serious financial problems that many news organizations are having. I think what Gorsuch was talking about really was much more applicable, well, he said exactly what you said, is much more applicable to what goes on online, where individual people writing on Twitter or wherever they may be writing probably do not share that kind of commitment, and I think the standards get hard to apply.
And I'll answer this by saying the answer is, I think, what hopefully every single first-year law student has learned on their first day of law school, which is the answer to every single question is, it depends, right? And I do think in part it does depend. Are you operating in good faith or are you operating in bad faith?
Absolutely. Well, I think we should open it up. Professor Collis, you want to take some questions from the audience?
Am I leading that? I thought you were leading the questions from the audience.
I will happily take the questions from the audience. I assume there are questions in the audience. We have answered all of their
That's really
defamation
good.
questions. I'm impressed.
Did I ask one?
Yes.
Could I ask all of the panelists, what do you think the chances are of New York Times versus Sullivan being substantially modified within the next 3 or 4 years?
Since I'm the non-academic and non-advisor on a day-to-day basis, I'll answer first and say I think if it's not zero, it rounds to zero. I think it's highly unlikely they're going to disturb the standard in any meaningful way in the next decade.
What I think could happen, and this is based partly on reading Gorsuch, but it could, I do think that the Supreme Court, if you go back and read their cases on the definition of public figure, I think the original cases, Holstone, Firestone, that they were quite narrow in who a public figure was. And then the broadening of the public figure category really occurred in the courts below that. And so it wouldn't surprise me, and I don't think it would be revolutionary, if they took a case and came back and said, you know what, we really meant it when we said the category of true public figures is narrow. Now, would that make a practical difference in the end for a while, maybe, and then it broadens back out again? I don't know.
And it did peak in Rosenblum and et cetera in the early 1970s,
Right.
and then even then it's been sort of cut back, and they just haven't said anything for it.
Yeah. There's three main cases. Other than Gertz, there's three main cases: Hutchinson versus Proxmire, a case called Wollstone, and then Timing versus Firestone. So, and they were very narrow in who got to be a public figure.
And I think the core protection of Kynes versus Sullivan is here to stay for the foreseeable future.
And Lyrissa, what you're talking about is happening in the trial courts already. Like you're seeing that movement towards really construing public figure. You know, we got to the point where we're saying there are involuntary public figures and vortex public figures, and you're already seeing, I think, at the trial court level, that's starting to be constrained. Another question?
Hi, sorry if I'm losing my voice, but I guess one development that we've seen in the 21st century is extreme polarization in media, but also in kind of like geography. So the large media organizations tend to be located in cities that are very heavily skewed on political parties. At the founding, the jury was seen as one of the bulwarks against bad faith, libel, defamation generally. And if you notice, I seem to notice a pattern between the successful big money libel political cases that were mentioned during this and the ones that have been unsuccessful seem to be more conservatives have been on the hook. I'm wondering to what extent the fact of that geographical change in America combined with the trust in juries should have an impact either on doctrine or just how we think about media defamation in a highly polarized society.
Well, somebody has to talk about the Florida law. All right. You know, that's a great question. And Lyrissa alluded to libel tourism earlier. And one of the real concerns that we're seeing among the things that the proposed legislation in Florida would have done would be to make Florida a libel tourism destination by basically saying anything published on the internet, you can sue anywhere in any county in Florida. And I just see plaintiffs' attorneys lining up in Polk County, Florida, notoriously conservative space, conservative juries. I think you could find the right cases to send there, right? And so I think that's absolutely a concern. But I also think that, you know, a lot of people talk about the press has lost its objectivity, but we can't forget that this country was founded with a partisan press, right? And sometimes just to provoke my students, I'll ask, and I want you to think about this, would it be so bad if the press just came out and acknowledged a particular slant, right? And so we kind of knew as consumers what we were getting, right? And we could sort of digest a little differently. I think that there's some interesting things there, as opposed to I think a lot of folks in journalism trying to say, well, no, we're objective. Not to take us back to postmodernism and is there really truth, but I think there could be some value there too. Other folks?
I just, two quick points. One is that juries are rarely get heard from in libel cases. In that I've been at the New York Times for, I think I'm doing the math right, 23 years. And there have been 3 libel cases that went to a jury. And so what goes on inside the jury box, we probably don't have a really good sample set. The other thing is that, and this goes back to a point that I've been making for many years, I grew up in a very conservative place, rural Illinois. My mother and my father were both World War II veterans. They were deeply conservative. They believed in freedom of the press because they did not want the people in Springfield to continue stealing from them. Okay? They thought maybe a free press would stop that. And I'm hopeful that at some point, and that, I think that's one of the terrible things that have happened here, is that press freedom has been seen as a democratic value, and something else has been seen as a Republican value.
Big D Democratic, not little d
yes, you're
Democrat.
Exactly right. Left and right. And I continue to hope, and I get certainly more and more discouraged every day, that we'll find a way back to finding that common ground, that freedom of expression is a good thing for all of us.
Well, and I will point out on that Florida bill, so the representative is called Alex Andrade, and he's actually married to one of my former students, which he brought up when he called me after I wrote an op-ed against his first bill. And he said, she spoke really highly of you. So I thought that was nice. Anyway, so when Andrade put out this second bill, the conservative, well, first off, the first one was killed by the conservative press being worried about it.
Yes.
And when he brought out the second one, there was a furor amongst conservatives, even at the federal level, about this bill because of how it might be used against conservative speakers in light of the recent verdicts, which is super interesting. One of my professors at the University of Texas, Jack Balkin, who's now at Yale, is a First Amendment guy, and he wrote an article about ideological drift. Yeah. And it is a profoundly, once you have the concept in your head, it's a profoundly explanatory concept. And what the concept is that an argument that in one period of time is a conservative argument, in a later period of time when things change becomes a liberal argument, and then, you know, in cycles of history. And once you fully internalize this argument, you try to convey to people how important it is to have neutral free speech principles that are not partisan in nature, and that you attach yourselves to them. And especially in the realm of free speech, one of the things I've been contemplating recently is how inevitable it is a call for censorship. Censors never claim they're acting out of bad motives. They're acting to protect you. They're acting to prevent harm, right? And so only if you have a deep commitment to this principle of free speech can you counteract that natural human tendency on both sides to, you know, say, my opponents are dangerous. We got to do something about them.
And amen to both what Lyrissa and David said about finding common ground. And I hope, again, that we should all be on the same side of finding the truth.
Absolutely.
And that is the most important.
Absolutely.
Yeah, I think students have to go to 105 class. So thanks so much to all of our panelists for being here.
Nice last word. Agreed.
And if you have any burning questions about what it's like to be the lawyer for the New York Times, join us in the Sheffield Massey room.